Peeps, you're still online?
Don't get straight, no, I ain't getting straight. Don't get straight, I ain't getting straight. I'm sick of the suffering, can't stand the pain. Don't get straight. Well, we know the story. Oh, ain't the way they say we can see. They got you Brendan's head. Totally insane.
Man, he's got some great intro music. Really good intro music.
They got questionable evidence. Yeah, they buy and they walk, but it makes such sense. While they're in the game, don't get strange. Don't get straight, no. Oh, now I ain't getting straight. Don't get straight. I ain't getting straight. And that lying, that cheating, that predatory sweaty, anything he said, he couldn't throw away. He's a legal stain.
Legal stain.
Oh, me, we find out who's to blame. Don't get straight.
Great stuff right there.
Everybody, happy Mother's Day, everybody. Hi, Travis.
Happy Mother's Day. Hey, Erekose. I just glanced over at my phone real quick, just so to remind people, I don't really watch the chat stream when we're doing a presentation, but hi, Linda. Hi, Allie. 7Pop. I don't think we've ever had a chance to talk yet, but I really admire your work a lot. Hello, Allie. Nice to see everybody. Happy Mother's Day. I got a really cool person with legal background that hopefully will pop in later. I don't know if they will or not, but we'll go through this civil case, this responsive pleading. And how you been, Erekose?
Oh, all right. Bit of a technical issue at the moment, though, if you didn't notice.
Well, I just see this beautiful logo.
Yeah, I know.
Very professional, but
yeah, I know. I'm sorry.
But I know you're there because
all right, got it fixed.
I still don't see you. Oh, okay. Serious question now. Do you have a makeup artist? You have a makeup artist and hairdresser now?
No, I
because
don't.
No. you seem to have good color and your hair is perfect. To quote one Yvonne,
it's a little bit.
You got perfect hair and great color. Last couple of weeks I've been noticing.
Right on. Cool, man. I got it cut right before Marathon, obviously, so it's well groomed at the moment.
And I like the tie. Looks really good on you.
Folks. You want to see the tie, folks? So you got the Wrecking Crew, Kose's Wrecking Crew tie. Get a little further away, maybe it'll get clearer. Anyway, so Kose's Wrecking Crew tie. Paul and I each got one of these. So if you guys want, you can go to the Zazzle website and get one. There's one for Mammothon. There's one for Wrecking Crew. So I'm sure Julie Pom Pom will be posting the link in live chat for you guys. So we're here today talking about, obviously, like the title says, we're talking about the motion to dismiss filed by the lawyers for Netflix and I guess for Laura and Moira and Chrome Media, their production company, right, Travis?
Correct.
Right. So there's
Yes,
a motion
sir.
to dismiss, and that's what we're going to be talking about today. And honestly, it's really kind of funny to read because, and Travis will, obviously explain a little bit today, but it's just basically they're saying over and over again that the burden isn't met here for this to proceed any further, especially against Netflix. Colburn, Mr. Colburn does not, come up with substantial proof that they maliciously did this knowingly and all that sort of stuff. And, so that's what we're going to be talking about today. But it's just like, it's so funny because they're citing so much case law that supports what they're saying. I mean, just multiple cases and everything. It's really interesting and funny to read. So any thoughts, Travis?
Yeah, well, just at the beginning, I wanted to bring up one thing. Really, I want to answer everybody's questions and whatnot, but people may be asking themselves, okay, how does this relate? Why do we care about the civil case, Colburn versus Netflix? And there's a couple of reasons why this is important. And I've mentioned this in the past, but in West Memphis 3, one of the biggest breaks in the case was the stepfather, whose DNA ended up being found in a critical piece of evidence, a shoelace, filed a defamation suit against Natalie Maines and the Dixie Chicks. Mm-hmm. And they, in defending that suit, proceeded to depose the lead investigator and also the stepfather. And they got tremendous valuable information in the case because one of the issues in a defamation lawsuit is the truth. Truth is an absolute defense. So they are allowed, if the case isn't dismissed, they would be allowed to proceed towards the discovery of Colburn and would be allowed to prove that he planted the RAV4. So let me repeat that again. They would be allowed to pursue discovery to prove he planted the RAV4. Right. And so that is why Jerry Buting in December tweeted, "This is the biggest Christmas present." I can't remember if he said Kathleen could ever get, or we could ever get, or Stephen could ever get, but he said it was the biggest Christmas present that could ever possibly happen. Right. And that's the reason why. But that's how it relates, or why it's of interest to supporters of Stephen and Brendan. Yeah, it's going to be interesting, right? I mean, if they do get to start deposing Colburn, I mean, because now they got what KZ's been digging up. They're going to have Kevin Ramlow's statement of him saying that he informed Colburn prior to the 5th of where he could find the RAV. So it's like there's a lot of things that I think no matter how you look at it, Colburn's on shaky ground, right? I mean, I don't know why he felt confident enough to bring this in a lot of ways. I bet, maybe he knows something we don't. Well, so someone we don't. Anyway, I don't know. One of the reasons is, like we've speculated, the police unions are very strong in the Midwest and the East Coast. They're the association they typically belong to are local lodges of the FOP, Fraternal Order of Police. And this is something that sometimes police unions will back up and support, because it might be something that's of interest to the general membership, to show that they're willing to finance and strike out against any type of attack, perceived attack on one of their members. Or it could, it could be publicity for Michael Griesbach. Typically, when things get filed on the day before the last day of the limitations period, it typically turns out that that they didn't think it was the strongest case. Not always. Sometimes because of whatever. People aren't aware that they have a claim, and it takes time to find an attorney or whatnot. But something like this, no, would have been aware of this a long time ago. And if typically what happens if somebody really feels strongly that they've got a super solid case that's worth significant sums, we all know it's not difficult to find a lawyer to take your case if you have a good solid case and it's worth a lot of money. I mean,
right.
We all know that.
Right. Or it could be worth a lot of money, right?
Well, yeah, I'm not saying there's any merit to it. I'm just saying that typically cases that have strong merit that could be worth significant sums,
right,
would have been filed within days, weeks, or months at the most, not years of the release of
right,
documentary or television show or newspaper or magazine, whatever it is.
Right. Okay, I see what you mean. So obviously, to get to one of the first things would be the fact that in this thing, they're establishing the fact that this thing is kind of falls flat on its face kind of almost immediately, because Colburn, through his job title and that sort of stuff, and the fact that he actually ran for head sheriff in 2007, he lost to Herman, but he ran. He was a public official running for office, right? So because of these various reasons, he is a public official, and therefore he is open to some criticism. We here in America are allowed to question and question our government officials and question the way our government works, because that's one of the things that makes America great. So long as they don't pass another AEDPA that robs us of that. But that's still one of the things that makes this country great, is we are allowed to question our public officials, our government officials. And so they're pointing out that he meets those requirements, judging by past case law, where people in a similar position to him were considered public officials and therefore open to public speculation. Right, Trav?
Absolutely. And, so there's, when you go to law school, or, I'm sure it's still the same, even though I went to law school eons ago, but when it comes to defamation, you learn about two cases to start when it comes to defamation in the law and defamation and the First Amendment, defamation in the media. One is New York Times versus Sullivan. And Sullivan was a public official. The other is Gertz v. Welch. And Welch was a private person in Chicago. He was an attorney who represented the family that was suing a police officer. And the John Birch Society mounted a campaign against him. As part of an attack. We're saying that it was the communist intention to take over the United States, and this lawsuit and Gertz, by implication, were part of this big communist conspiracy. So he sued, Gertz sued Welch and the publishing company for the John Birch Society. You learn about those two cases, and of course, it was no surprise. You see it cited throughout here. But what those cases between them say is, in regular defamation, it's strict liability. If you say something that's clearly a matter of fact and you cause injury to somebody and it's untrue, they win. If you're a private person, not a public figure, but a private person, like an attorney suing on behalf of a family that was killed by a police officer, you're a private person and you sue a media outlet, you have to show at least that they were negligent. There's no strict liability. You can't show what they published was false. That's not enough. You have to show that they were negligent in some way. That's different than other common law countries like Canada, especially Great Britain, and to some extent Australia. But in the UK, it's still strict liability. If you are wrong, the plaintiff doesn't have to show that it was intentional or that it was negligent. You pay. We're a lot different because of our constitution. We have a written constitution, unlike the UK. Our constitution has the First Amendment. And so the free speech and the First Amendment sometimes collide. The free expression of ideas, but not to the point where they're slanderous, libelous. You can't go out and lie about private people that haven't interjected themselves into the public to cause them harm. One example would be, and this is one of the areas where you don't have to show specific damages, is accusing someone of what they call a loathsome disease. And that's, back in the day, it was gonorrhea or syphilis. If you accuse somebody of having gonorrhea or syphilis, you had an automatic case. Well, if you put too many restrictions or too much liability for defamation, it would have a chilling effect on
the press,
freedom of the press.
Right.
And so those two concepts collide.
Right.
And so we decided, if you're going to sue a publication, if you're a private person, the Supreme Court, and these are cases from the 60s. So it's the Warren Court, which is also the court that basically changed criminal procedure to provide many more protections for defendants, like Miranda and many, many others. But anyway, they said a private person suing a media company, you have to show at a minimum negligence. States can have a higher standard like Malice, but you have to show something more than strict liability.
Right.
And then if you're a public figure, you have to show what we call actual malice, which is knowing falsity, it's false, or reckless disregard for the truth.
Right.
And so we're going to keep seeing these concepts over and over and over in this motion to dismiss.
Right. So basically what Ali's saying, folks, I agree with. I mean, it's okay for us to question Colburn and talk about it like the way I do here on my channel, but I disagree. I basically agree with her that it's not good to personally contact him, threaten him, and do things like that. So I just want to go ahead and say that because it's becoming a big conversation in the chat here. So I just wanted to let everybody know where I stand on that topic. So, all right. He's not wrong for suing. I don't think he is either, because now he's going to get deposed and and possibly Netflix and the filmmakers are going to get the chance to try to prove he did exactly what they think he did and what they're saying he did. So, and we have more, evidence of it now that I'm sure Zomer would be more than happy to help with, like Kevin Ramlow's statement, stuff like that. So So let it go, right? Let it run, let it buck.
Yeah. If this motion is granted, there will be no discovery.
Right.
The way Colburn's attorney will respond to this, assuming they weren't out just for media with the complaint, they're really not pursuing it that seriously. But assuming that's not the case, they'll vigorously defend it and file an opposition. And what they'll do is say that Netflix has raised questions of fact. So there's questions of law and there's questions of fact. A motion to dismiss at this stage can only be granted if there are no questions of fact. So they'll file an opposition that says there's clearly questions of fact. We want to convert this motion to what we call a motion for summary judgment. And we want you to allow us X number of days to pursue discovery. Netflix will then file a reply, and they'll say, no, they're trying to convert these to questions of fact by saying they're based on information or belief, but it's clearly untenable. We believe these are all questions of law that are appropriate for the court to decide. And then the court will decide whether there's questions of fact or not. If you don't believe there's any questions of fact, they'll grant the motion to dismiss, and it'll be dismissed as against Netflix. Or they'll say, well, we agree, but we're going to give you time to amend your complaint to fix it, and we'll give you a certain amount of time to do that. Or they'll say, we agree there are questions of fact, and we're going to let the case proceed and go forward with discovery.
Right. Okay. All right. So do you have any particular places in the motion that you thought were interesting? Or?
Oh, good Lord. It's 30 pages and it's hysterical.
No, it is. It's funny.
You know,
We can start at the beginning because the first opening pages are pretty good.
Well, there's a novel idea. Go through it chronologically.
I don't know if I want to go through all 30. It's pretty redundant. It gets to the point of being repetitive.
So, you know, as per usual, I highlight stuff that sticks out to me that, you know, either interesting, funny, or that helps me explain a legal concept. The first thing that I highlighted is actually the last sentence of the first page. The series titled Making a Murderer, then it goes on to page 2, explores issues of the utmost public interest and concern. Who can't agree with that?
Right.
So they're
a lot of us concerned about it.
Yeah. So that's one of the things why they're saying that is they're going to keep coming back to it, that just like you said, the free exchange of ideas and debate and criticism of local public officials is of the utmost concern and benefit to a free democratic society.
Right.
And that's why they start with that overarching concept. And then they lay out the standard. They use the Garrison case, which is, you know, very similar to New York Times versus Sullivan. It says, you know, what in a defamation case, in order to prevail, if you're a public figure or a public official, so you publish the documentary series or newspaper or, you know, whatever the media is, with actual malice, i.e. either knowing it was false or despite a high degree of awareness of its probable falsity.
Right.
And then as they point out, and here's that case, the first time we've seen it, even if Colburn was not a public official, which I think they clearly show in here that he is.
Yeah, I think they do too.
The defendant negligently disseminated material falsehood about him, and they cite the Gertz case. Anything stick out to you in those first 2 pages?
Let's see. There was something about I can't find it now.
Well, you talk about there in the paragraph that starts with regard to defendant Netflix.
Right. Let's see.
They're distinguishing between the co-defendants, which is Chrome Media. That's the production company for Moira and Laura.
Right. And right.
And Netflix. And they're pointing out that there's a difference right there from the get-go, because later on they're going to point out that unlike the production defendants, they don't show that Netflix
was any part of the process or anything
other than release it, and there's no liability just for releasing it. Right.
They it goes through this often, talking about how bringing anything against Netflix here is laughable because they really have a very high bar to meet to make this stick to Netflix. In other words, they have to show Netflix had actual malice. They have to somehow prove that they had this foreknowledge and actual malice to do this to Andy Colburn.
Right.
When it's all, and it's just ridiculous. That's not going to be. They're never going to get that. So that's what's interesting here. So they're saying it's totally out of bounds trying to bring in Netflix. I think it gets to but what it does say is his motion does actually say more about the filmmakers, and so there is, the claims he's making against them are, I guess, a little more likely to stick, or possibly have a little more chance. But I think it's all getting kind of, dismissed under the fact that he is a public figure and he is open to this kind of criticism. So it's very interesting, though. Sorry, go ahead. No? Okay. Setting aside all of the problems with his lawsuit, most fundamentally, the making a murderer contains no false statements of fact about him. He has not plausibly alleged that Netflix distributed the documentary series negligently, much less a requisite of actual malice, which we were just talking about. You want to talk about procedural history? Travis, you with us? Hello, Travis. Is he frozen? We must have lost Travis there. All right. So, as Colburn concedes, Avery's defense at his murder trial was essentially that Colburn and another sheriff's deputy, embarrassed by their role in the botched investigation that led to Avery's wrongful conviction and facing civil rights action, planted evidence to ensure that he was convicted a second time. Colburn objects, however, to the series' recounting of that theory. He alleges that by selectively editing trial testimony and by purportedly taking his statements and actions out of context, ridiculous. The defendants misled viewers into concluding Avery is innocent and Colburn is crooked, and I don't think that's any kind of misleading going on there at all. Colburn has never explained himself. He keeps making ridiculous statements like he played twist and shout with the cabinet and the key just popped out from Narnia. Well, he doesn't say Narnia, but there's no way it could have been hidden cleverly. There's so much he says that's ridiculously just false and wrong. So anyway. Hopefully Travis is going to be back here soon. But also that's just They say he sprinkles the phrase actual malice throughout the amended complaint that he made. But neither it nor its predecessor contained a single allegation describing Netflix's role in the series production. So on and on. So it's not Netflix's fault, or how Netflix isn't part of what of the making of the film at all. They just ended up releasing it, to a worldwide audience. The amended complaint does not contain any statement of alleged fact regarding Netflix's state of mind with respect to the truth or the falsity of MAM that could plausibly support Colburn's conclusory claim that Netflix acted with a requisite degree of fault. And like I said, this is all, having to do with the fact that he's actually a public figure. Instead, wherever the phrase actual malice or some other allegation of knowledge of falsity or negligence does appear in the amended complaint, Colburn either discusses the actions taken and knowledge possessed by the producer defendants, not Netflix, or he simply refers to defendants vaguely and generically, and then alleges in conclusory fashion, and sometimes even on information and belief, that he acted jointly, severally, or in concert. So interesting. He's just this part basically keeps going over the fact that this being brought against Netflix is ridiculous. I'm going to switch back to the chat for a second here while we're waiting to see what happened to Travis. I'm guessing he forgot to plug his laptop into power and he's waiting for it to come back up now. Teaching something with you show, no worries. Yeah, no worries, Trav. Go ahead and work out your difficulties, buddy. I got it. All right, so we'll go back. By the same token, Colburn implicitly concedes that it was only Ricciardi and Demos and not Netflix who attended Avery's trial and edited hundreds of hours of raw footage into what became the final series. You hear that slapping noise? That's, yeah, anyway. Let's see, who attended Avery's trial? The raw footage of the series. See, for example, and this is basically where he claims that they strategically spliced things. These are all from his complaint, his amended complaint, and it's all to do with Ricciardi and Demos, not Netflix. That's what that's pointing out. I'm going to take that off since I don't know if Travis is coming back or not. So, finally, in addition to the allegations of the amended complaint, the following evidence relevant to this motion is properly before the court, either because it itself contained in MAM or is therefore incorporated into the amended complaint, or because the court may take judicial notice of it. And it's just suggesting stuff that the court could review for this. Legal standard. Test whether the complaint states a claim on which relief may be granted. To survive a Rule 12b motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. The complaint, factual allegation, must be enough to raise a right to relief above the speculative level. A pleading that offers labels and conclusions or formulaic recitation of elements of a cause of action will not do. Considering a motion to dismiss under federal rule and procedure, the court may take judicial notice of public records, including other judicial proceedings, Henson versus CSC credit servings. The court may also consider documents referenced. How's it going there, Hooch? That's the dog, folks. And they are central to the claim, such as the entire contents of MAM, which is the subject of this lawsuit, and the transcripts and the judicial proceedings referenced in the amended complaint. Let's see. The United States has found or has a profound national commitment to the principle that debate on public issues should not be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Sullivan. As a result, and as the Seventh Circuit has put it, service as a public official is not for the thin skin, even or perhaps especially at the local level. And they cite Manley versus Law. There's Travis. Hey there, Travis. How you doing, buddy?
Totally concur.
Yeah. Well, welcome back, Travis. Welcome back. It's good to see you, buddy.
Yeah, no problem.
Make sure you go over
Anytime.
and subscribe to Travis's channel. You know, we want Travis to go live from Raleigh.
How you doing?
Hey, buddy. How's it going?
That was a total legit computer failure there, though.
I think I figured it was.
It's crashed.
Yeah, he usually doesn't just fall out.
Yeah.
So. But
how was your weekend? You had a bit of a weekend off, hey?
Kind of took the weekend off, yeah. But it's okay because then there's been other people popping up. Did you see Linda K. Breyer? She did a live yesterday. Linda
Yeah, that's right. I didn't catch it. I was in transit down to Austin, Texas here.
More people involved, you know.
Yeah.
Being occupied over there by the
divvy up
by the steers. Anyway.
Uh-oh. There's
the Longhorns.
Are we still here?
Yeah, we're here. I hear you. Can you hear me?
Hello? You can see me? Because I got a blank screen.
There's still.
Sometimes it's weird, but most of the time it's okay.
Yeah. And so, hey, I'm going to be coming up in you in a bit.
You're going to be coming up here?
I think so. In the next month or maybe I'll see you at Raleigh for sure.
Oh, okay.
And then,
that's good enough.
But sometime after that, I wouldn't mind doing the same thing I'm doing down here with Travis, just doing a few interviews and stuff like that. It's cool, you know?
Right on. Can't wait to see what you come up with, buddy.
Yeah, there's some fun stuff. I was talking, you know, the artwork that the Kathleen Zellner and the Superhero, that I was talking to that artist last night, Mo Sherwood, and he's out of Vancouver. And we got some pretty good plans. We're going to try and put some stuff together anyways. So we'll see how it will. It might fizzle, it might not, but super fun continuing to build a narrative, you know, that is pro-Avery, pro-truth, pro-justice, all that stuff. So
Right. Yep, sounds good, buddy.
Yeah.
Everybody's saying
Well,
Travis.
you know what? I wanted to...
Everybody's saying Travis got kind of hot.
Well, Travis is going to be back because I'm going to go back to doing what I was doing, and he's got the legal mind. And so,
right,
hey, everybody, thanks for subscribing too. That was so great. I think I broke 700 today, so we're close.
Awesome.
Yeah, and thanks for your promoting it too, Richard. That's awesome.
Yeah, awesome, dude.
Yeah. Okay. So
popping in.
Here's Travis again.
I'm not going to follow that. I mean,
You're not going to follow that?
yeah, this is like the Who following Jimi Hendrix at Monterey, man. I mean, the guy lights his guitar on fire and then walks off stage and looks at Pete Townsend and goes, "You wanted to go last? Follow that, asshole." How am I going to follow that? Hot. Now he said, Travis got hot. Well, and it's really nice to have Stacy down here for a couple of days. We're going to check out the legal environment of Austin and environs, and we're going to go see some friends of mine that are into music, and we've been talking about the case all day. You just can't stop talking about it, and it's so knowledgeable. I don't know if Allie's ears were burning, but talking about her knowledge of the case, we wish she would go on with use some Erekose a little bit more again. And of course, we were talking about how long I've been watching you and everything, and why I kind of latched myself onto your channels, your knowledge of the case and presenting things in an accurate way. We really appreciate you and all of your crew. Where were we?
I don't know. I got to page 11.
I'll tell you. How far did you get? Man, you were doing great. You were doing really good.
Yeah, that's fine. I'm on page 11, the argument.
You got up to 11?
Yeah.
Okay.
I was kind of skipping some stuff or whatever, basically, but read most.
Okay, let me pull that back up and get that going. Of course, that program closed when my power cord unplugged. And hey, there was several requests. Where's your dog? How come you
kind of hanging out
never
right
put your dog on? It's a big dog, right?
He's kind of a big one. Come here. Come here. Come here. He's just staring at me. It's not my dog actually either, but hold on a second.
You already covered one. He ran for election, and he had thousands of votes. He ran for city constable in another city. It didn't talk about his votes. It talked about his commentary. He released a press release for God's sake about how he hopes it would bring closure to somebody. And
Hello.
that was a major, as you referred to it, slap. His allegation and the complaint that he didn't interject himself into it. You go back into MAM1. I noticed it just because I'm familiar with how law enforcement will stage certain things. But count how many times. We should do this as a trivia thing sometime, make a game out of it. You look how many times Andy got himself situated to be escorting Stephen to jail, Stephen from jail, Brendan to jail, Brendan from jail.
Right.
He's with them at every critical photo op minute. Clearly some campaign guy is suggesting to him, hey, would it be possible for you to escort Brendan to jail after the verdict? And I mean, it all looks staged. It's crazy. But anyway, I don't know if you all caught that, but he clearly interjected himself into camera angles. I mean, he's like the John 3:16 of making a murderer.
Yeah. I mean, he certainly was involved. Certainly. I mean, yeah, I agree.
You all know who John 3:16 is, right? He's the guy, Monday Night Football, always managed to have an end zone seat. So when they kicked a field goal, he held up a sign, John 3:16.
Right. Okay.
Not being,
Right.
not getting religious on anybody, but he was a guy who was a master at getting himself in at the right camera. he knew where the cameras were and he knew where they were going to be pointed, and he was a master at getting free publicity for his cause. Well, you know, Andy Colburn sure ended up in a lot of shots in MAM 1.
Yeah.
And I think it's total disingenuosity to say he didn't inject himself into it.
Right. There's, you know, and they go on to say you can't prove actual malice or a high degree of awareness on Netflix's part of the probable falsity. You know, the actual malice standard is subjective. Reckless conduct is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. It requires a public official, plaintiff, to focus on the defendant's conduct and state of mind. Babb versus Minder, and to prove by clear and convincing evidence that the defendant made false statements with a high degree of awareness of the probable falsity. In fact, Netflix didn't make any statements here. So, you know, you hear that, everybody? Anyway. Moreover, the defendant's state of mind at the time of publication that matters. Actual malice cannot be inferred from a publisher's failure to retract a statement once it learns it to be false. So, Colburn is self-described as a sworn law enforcement officer who investigated Halbach's murder and testified against Avery at trial. Is a public official. Because his amended complaint does not adequately plead actual malice or even negligence, and because any attempt to amend it would be futile, all of his claims against Netflix should be dismissed with prejudice. Tab? Anything to say? Still there? Uh-oh.
Okay, right there. So what I was talking about earlier is that one of the things that in their opposition is that they'll come back and say, look, we think there's a question of fact. Number two, even if you don't find there's a question of fact, Judge, please allow us time to amend our complaint to fix it so that it does withstand scrutiny. They're anticipating that argument ahead of time to say it would be futile. And one of the examples of futility was the lawsuit involving Barack Obama and his birth certificate. And a citizen in California filed an objection saying he's not a citizen of the U.S., he can't be president. And they came back and they attached an affidavit from a nurse in the delivery room in Hawaii that did an affidavit saying, yeah, I saw him, he was born in Hawaii, and the court said, we're dismissing this. It would be futile to allow this plaintiff to amend their complaint to try and state a viable cause of action. And so that's what the lawyers for Netflix have done. And they said, Judge, if they do ask you to let them amend it, you should deny that too, because it would be futile. That's what that's going to. They're anticipating the opposition.
All right. Where's my note?
What page are you on now?
12. It's right where it says Colburn is a public official, where they go through, the reasons why he's a public official.
You there?
Yes, I'm here. Hello.
Uh-oh.
Can you hear me? Let's see if everybody else can hear me. Can everybody else hear me?
Good though. I like this.
Erekose, can you hear me?
No.
Can anybody hear me?
Can you guys hear me? Can anybody hear anybody? Hello, everybody. We can hear both of you. Okay, they can hear both of us.
Must just be some big lag. I don't know. Okay, we're good.
All right. Anyways, I can hear you now, so you can hear me now, I think. So, okay, here we go.
Yes, loud and clear.
All right. Okay, so anyway.
Yeah, I can all hear
public
you.
official.
What page are you on, Erekose?
12. You hear me? Uh-oh. Oh, Travis is cutting out. That's what I'm getting too.
Thank you.
There you go.
Thank you. Oh, man, you have no sense of humor. Come on. Thank you. Appreciate it. Page 12. I'm there. I'm there. I'm there.
All right, buddy. Anyways.
All right. So, you know, they go through now and in detail, go through the, what's funny, thumbs up. Okay. They go through in detail the various cases and whatnot. If anyone has any particular case they want to be more interested in or interested in me talking about, it's been years since I've read some of these, but you know, so they're going through it as they typically do, step by step. There wasn't really anything significant for me to talk about in that section, which goes up to page 16. They cite, you know, the cases that you would expect them to cite. They throw in the feel-good things like on page 16, quote, "There's more awesome power exercised by government. There's no more awesome power exercised by government than that of the police. The police have literally the power of life and death over citizens they are to protect." They cite the seminal case of the Journal Sentinel, the
Ariola.
I will have you say that as opposed to
Ariola.
me, but that's the guy's name. Anyway, as a result, the public has a particularly strong interest in being informed about its law enforcement officers. And, you know, that's a Seventh Circuit case, which, as everybody remembers, Wisconsin's in the Seventh Circuit. That's the very same court that shot Brendan down after he won. But, you know, they're pointing out cases that recognize why it's important for the media to comment about the judicial system and police officers and police departments in particular.
Right.
You know, it's extremely important. And if you made it easy to recover against a media outlet or publication, it would clearly have a chilling effect on the media's ability to report on matters of public concern. That's really all I had on that section, unless you had anything else.
No, I mean, it's just basically saying he's not, I mean, he is a public official. He is an agent of the government, and he is therefore open to criticism. And so he needs to have a thicker skin. I even saw that. I saw it worded that way even at one point, that to be one of those officials, you got to have a thick skin. So seems like there's a lot of case law here supporting that. So.
Yes, sir, absolutely. And so sometimes you file a motion to dismiss. It's very rare to have one granted under 12b6 because if you allege, again, any material fact, like attaching the affidavits about the election, for example, the rule says if you attach an exhibit, the court should automatically convert it to a motion for summary judgment. Again, a motion for summary judgment means that you have to give time to the plaintiff to conduct some discovery, even if it's limited. But they're arguing that, hey, that's a matter of public record. We're just showing public record, so it shouldn't automatically convert to a motion for summary judgment. But sometimes you file these things just to educate the judge or educate the media or the public, because you know in a case like this, it's going to be picked up by the media. It's going to be picked up by the public. Case in point, your live tonight is going out to people who are interested in it and how it may cross over. Now, one thing we want to keep in mind, I'm sure they're aware of, but is that so there's essentially two defendants. There's Netflix and then the producer defendants, which are the two individual producers of the documentary and their production company. But those three defendants, the two producers, Moira and Laura, and their production company are lumped together as one defendant and Netflix the other. And Netflix is taking the position appropriately that they're completely different. All they're alleged to have done is distributed the film. And so that's different than the producer defendants, which were responsible presumably for editing, reviewing the final product. As they said earlier in the motion, all Netflix did, they didn't edit it, they didn't cross-check, they didn't review trial transcripts. And that's actually significant. So I want to go back there just for 2 seconds. This is in that list of things on Snap, can't even find that. But they listed several things that, unlike the producer defendants, they didn't review trial transcripts, they didn't review trial video. Netflix didn't review all of these things that the producer defendant did. All that they've either been lumped in, Netflix has, collectively as defendants, or when they are talked about individually as Netflix, it's that they released the documentary series, and that they don't show anything they did to constitute the requisite fault. And so that's where we're at on page 16. Does not plausibly allege that Netflix acted with the requisite fault.
Right.
And then it says they have not pled.
All the complaints are literally about the filmmakers and not Netflix. Every complaint he makes doesn't actually apply to Netflix. Right?
Exactly.
So.
And then the producer defendants have their own motion to dismiss. It's a 12B5 motion. This is a 12B6. The 12B5 is based on jurisdiction or personal service. I don't know if people have read that one, but they're saying that they didn't, not only did they serve, that they file the complaint the day before the statute of limitations expired, they also point out that Wisconsin allows 90 days period to serve the complaint. And that they were late. And so the producer defendants should be dismissed because the statute of limitations expired. Which if that ends up being the case, that's automatic malpractice against Griesbach.
Oh, wow. That's
Oh wow is right. Yeah, if you blow the statute of limitations, now assuming, if they come into your office at 4 p.m., the day that the statute expires, no, but they filed it timely last day, and then it's completely the attorney's responsibility to make sure it gets served in a timely manner. And even though it's been removed to federal court, the laws of Wisconsin procedure control.
right.
And because it's diversity jurisdiction, citizens of different states. So,
All right.
so Netflix, one of the defendants is saying you haven't alleged properly that we're guilty of actual malice or negligence or any of the other things that are required. And then the other defendants have filed a motion to dismiss. It's the same lawyers, by the way, same law firm.
Right.
But you file them separately because the defendants are separate. And I believe it's pretty clear that the reason why the same lawyers are representing all the defendants is that there's an indemnity agreement. Indemnity is just, hey, if we get sued by releasing your documentary production, you agree to defend us and indemnify us. That's a standard thing that's done.
Right.
And so I suspect that the MAM producer defendants are paying for the defense of Netflix. Could be reversed, but regardless, the fact that one law firm is representing all the defendants tells me that there's some sort of an indemnity agreement between the two of them. But they both have motions to dismiss. Big shout out to Julie Pompom for sending me that other motion, because most people have been focusing on this motion we're going over tonight, because the other one is dull as hell. It talks about process servers and whether they got things served in time and how they served, but not anything talking about the facts of the case and the law of defamation. I'm going through here. I'm up to page 19. I don't know if you had highlighted anything. Just trying to see if there's anything I thought that was noteworthy, other than, they're pointing out they haven't pled actual malice.
It's just the same things over and over again at this point, really. If there's no actual malice, he hasn't he hasn't made any actual claims against Netflix. He hasn't, it's like the same drum beat. I mean, it's a good drum beat, but it's like the same one kind of that just keeps echoing throughout the rest of the motion.
Right. So, it's, so tell them what you're going to tell them. Tell them what you told them. There's nothing that's more applicable than that cliche or idiom, whatever the hell it is. Maybe Julie can tell us what that is technically in literature, but there's nothing more true in the law than, we are taught. Tell them what you're going to tell them, whether it's at trial or in a pleading like this. Tell them what you're going to tell them. Tell them what you told them. So we're in the tell them part. So page 21, I think this sums it up right here. Starting at the top, the amended complaints bear allegations with respect to Netflix failed to satisfy even this lower bar. As discussed above, whenever Colburn attempts to allege that Netflix distributed MAM with fault, whether actual malice or negligence, he does so in conclusory fashion. We heard that in the introduction, and only by indiscriminately lumping it together with the producer defendants. We just talked about that they lump them together. He does not do what the law requires, which is allege a lack of ordinary care either in the doing of an act or in the failure to do something. That Denny case they cite, by the way, is not the same Denny case in Wisconsin.
Different
requirements for third-party defendant.
In fact, he does not specifically allege Netflix did anything other than distribute.
Then they talk about page 23 again, because the amendment would be futile. The court should dismiss Colburn's claims against Netflix with prejudice. So a court can dismiss something either with prejudice or without prejudice. With prejudice means it cannot be refiled. Without prejudice means it can be refiled, can be amended, changed, refiled. That assumes that there's still time left on the statute of limitations. But they're asking it just be dismissed outright and they not be allowed to refile it.
Right. With prejudice.
Then they go through the law and then talk about all that. So page 27. Now, so remember, he sued both for defamation and intentional infliction of emotional distress. Intentional infliction of emotional distress is a tort that came about in the 1960s, first with California and then the restatement of torts. It's difficult to recover what we call IIED claim anyway. And what they point out, what they're trying to point out is that you can't get around the First Amendment by claiming IIED cause of action. It's still subject to the First Amendment. And that's what they cover in those couple of 3 pages over to page 29. And then conclusion, tell them what you told them. They sum it up. Then we got, so let me just cover this. Respectfully submitted, got James Friedman. He's out of Madison, Wisconsin. That's going to be their local counsel. Then you got Lee Levine at Ballard Spar. That is a very well-known law firm, and look where it's located, K Street in Washington, D.C. For those of you who don't know, all of the major law firms and lobbyists are on K Street. It's like being on Wilshire in L.A.
The designer shop.
The financial district, if you're a brokerage firm, every mid to large city's got a street where the guys are, the gals, and K Street is it in DC. And then, of course, that firm has offices all over the world, and they have another lawyer, Lita, who works out of the Minneapolis office. She probably covers a 2 or 3 state area out of Minneapolis, including Minnesota. I checked into a little bit on them. Neither one is listed as specializing in First Amendment cases, but I just did a very preliminary review. So I'll try and find out maybe other, if they've handled other litigation for, newspapers or television, that sort of thing. But I'll try and get that together. I looked at it when Julie Pompom sent me this material, looked at it on Friday and part of Saturday. Did you have anything to add on those pages? And then can maybe see if anybody has any questions. And I'm sure if I was looking at the live chat right now, they'd be asking where Stacy went.
Yeah.
And that's going to be their number one question.
Yeah.
Can Stacy come back? No, he doesn't have his guitar here, but I'm going with him tomorrow to pick up a guitar that actually belongs to a very, very famous performer. They're a family in New Orleans, and he's got a voice that is as sweet as honey. Let's see if anybody can guess that. You concur on that? That guy? Yeah.
I concur.
Yeah, yeah. Voice as sweet as honey, from family from New Orleans. So we're not going to do a music thing. He didn't want to fall with his
Stacy
guitar.
sure is shy about playing music.
Yeah, I know. Well, we're really, we're going to focus on talking about the case and helping them try to understand stuff. And
speaking of guitars, Allie Apperson, Pom Pom needs to speak to Allie later. Boy, that's an interesting. I wonder what the hell's going on there. It's trippy. Anyway, all right. They need to have a discussion about guitars. All right.
now I'm intrigued.
A new song coming out of them.
What's that?
Maybe they're writing a song.
Yeah. Oh, maybe they're right.
Apparently. So it looks like it is going to be something cool. Anyway, all right. Can't wait. Sounds exciting. So, what'd you think of the premiere today, dude?
Honestly, and I'm embarrassed. Normally I catch your stuff within 2-3 hours at the latest at it coming out, but I didn't want Stacy having to catch a Uber in a strange town, and I didn't want to trust it to anybody. So I got up at 6 or 7 this morning and cooked ribs for Mother's Day and went and got him. And we had mothers and the grandmothers over here today, and then wanted to reread the motion and whatnot, and we just didn't have a chance to check out your premiere, and I apologize for that.
No worries.
But we will, and we will have commentary on it as soon as you welcome us back, if you ever welcome us back.
Linda wants to know who them lawyers are in Minnesota.
They're part of the same.
So,
that's a branch office of the.
The one your local counsel is going to probably be James A. Friedman at Godfrey and Kahn SC, and then your other one, who's going to be like the local representation for Ballard Spar, is going to be Lita Walker, spelled Leita Walker. She works for Ballard Spar. She's like the regional person. She's in Minneapolis. This is all at the end of the end of the motion dismissed. By the way, folks, you can find this. Julie Pom Pom can get you the link, and you can get. They have their address, whatever. So anyway.
Yeah, you're right. Everything you just said is exactly right. It's the same law firm. It's a mega firm in Washington, D.C., but they have branch offices all over the world, and they have a branch office in Minneapolis, and Lita is at the Minneapolis office, but they're the same law firm. And then the Madison law firm is acting as local counsel. But they are a major litigation player in Madison as well. There's no, just like I said, when this thing was filed, there aren't any lightweights on the defense of this thing, and they are billing at massive rates per hour. What you're looking at there probably cost over $100,000.
What?
What you're looking at there, that 30 pages of document,
Right.
the background and the research and everything that went into it, you're probably looking at least $100,000 in attorney's fees.
That's significant.
Just
Well,
that.
Dropping the bucket
Well,
considering what they paid, really. But
We're worth it. Hey, anything for the First Amendment, anything for justice, right?
yeah. Well, I mean, hey, it'd be nice if our system didn't require so much money to fairly litigate things, but apparently right now at our current stage of evolution as humans, here we are.
So are you suggesting, Erekose, that maybe school teachers should make more than lawyers do?
I'm actually not trying to say whether anybody should make as much or more than anybody else. I'm just saying that it costs quite a bit of money to litigate things in this system. And honestly, being able to litigate things in this system is literally being able to tell your side. And not everybody has the money to do that. So there are inequities, and I'm not going any further than that.
Well, maybe we should just all make the same and then have a level playing field. Everybody make the same.
You're a socialist?
No, I'm just, you seem to have a problem with people having.
I did not. No, you are putting words in my mouth. I'm not saying I have a problem with lawyers making money. I'm saying it's very expensive to do. You can't deny what I'm saying. Anyways, whatever, dude.
Well, not everybody can afford a top-notch security system, surveillance system, sound system with speakers in the ceiling and wiring for big screen and all of the stuff. Not everybody could afford that either, but I don't see you complaining about that. I'm kidding.
I was going to say the difference is those people can go online and teach themselves how to wire it themselves, and they can cut out the middleman. Whereas with law, you got to have somebody with a bar. You got to have somebody that passed the bar, so it kind of prevents you from skirting the, anyway. But, just saying.
Well, to quote the judge in Caddyshack, the world needs ditch diggers too. I'm just being trying to be humorous here.
And I've dug a few ditches in my time. Hey, and sometimes still do. So
yeah. But I'm failing at trying to be humorous. But seriously, it's a point well taken that people who do not have a lot of money are the presumption of innocence is supposed to make it a level playing field for a lowly defendant, uneducated, no money, who's appointed a lawyer. Keep in mind, the law required the appointment of lawyers in felony cases was only in the 1960s. Gideon versus Wainwright. Can you believe that? I mean, the only time you were entitled to a lawyer to represent you if you were poor in Florida, for example, was murder or rape. I mean, can you even fathom that? That's not that long ago. And the way it was supposed to be leveled is a presumption of innocence and making the state get over this huge bar, which has eroded and been eroded both by court decisions, by the rules of evidence on what the state's allowed to bring in, on bad character evidence, and on and on and on. And so it is now completely unrealistic to expect that a defendant can defend against a giant government prosecutorial team. There's no way that the poor can mount a significant defense. And those numbers that we keep seeing bandied about by the, different innocence projects and the studies, and they're extrapolating data, how many people are in prison in the US that are wrongfully convicted? And, whatever the percentage, 4%, 6%, 10%, let's just say it's 2%. We have more people locked up, both in absolute numbers and per capita, than any other country on the face of the earth, including big old bad Russia and, Iraq and Iran. And, where we complain about their systems and the way their judicial systems work, or if you could even call it a judicial system, but yet we've incarcerated this mass percentage of people, and we've adjudicated kids as adults and incarcerated them. And we have no hesitation of doing that when they have one arm held behind their back, in some cases, two arms. Stacey and I were talking earlier today about the Memphis Three case, and had a mentally, socially challenged kid that they, of course, there's hours of the quote confession that weren't recorded, and it was on a audio tape. They kept feeding him stuff, and finally, it started out, it happened during the day. Of course, the three murdered boys were elementary school kids that were in school during the day. And it went from 10 a.m. to noon. By the time they were done with Yessie, Miss Kelly, it was 5 p.m. We're getting dark.
Right.
They were so lucky that people, they saw an article in a national newspaper. Does it sound familiar? That somebody picked up on that it was satanic panic, and it was just starting. And so these producers, these documentary producers, saw a little clip in some newspaper and said,
"Yeah,
man, this might be interesting. Let's go down there."
Right.
And
stuck with it for 10 years.
If that hadn't been picked up by HBO, there's no question in my mind Damien Echols would have been executed by now, and his co-defendants would still be in prison to this day. And that's the sad part about it. There's the staircase. He wasn't poor. He could mount a defense. It financially devastated him. And then, he could mount, he had all of the ammunition to marshal. And then because I know there's more controversy on what, people think about whether what he's guilty or not, but people are sharply divided on that. But that's just an example of, you can have a tremendous amount of money. His attorney is considered one of the top criminal defense trial attorneys in the country, and did a phenomenal job with that case, and turned out the way it did. And fortunately or unfortunately, depending on your perspective, he had the money to pursue an appeal, and they worked out a resolution. And some people are upset about that, about the Alford plea. The West Memphis Three guys entered an Alford plea, so to avoid any risk. But Money, you can see the difference that money can make. There's no question in criminal defense arena that money is the only way to truly come up with a level playing field, because we have eroded the presumption of innocence in the name of what? In the name of let's get tough on crime.
Well, yeah. And how likely is that to work, really? Because think about it. How do things in life really react in life when we decide, you know what, that's not working, let's hit it with a bigger hammer? How often in life does that kind of plan of action actually work out for the better? Literally almost never, right? And I use that as an analogy, hit it with a bigger hammer. You know what I mean? It's like, and that's what we're doing, by saying that, oh, we want to feel ultra safe. We want to try to put away all the criminals, but in the process, we are stripping ourselves of our rights to help ourselves, to help protect ourselves if one day we ever find ourselves on the wrong side of the law, or the wrong side of the state's accusations, and stuff like that. It's a concern, and
you've said this. I'll remind you of what you've said over and over and over again. That's how you end up with EDPA. That's how you end up with the Patriot Act. You name it something really fancy, and in the interest and in the name of let's get tough on crime, let's focus on the victims of crime for a change. What about their rights? And you package this stuff up. This is what you end up with.
Yeah, absolutely.
Oh, that's a big
we have to be careful, folks, because trust me, I wouldn't be surprised if in the next, say, 5 or 10 years, they come after our ability to criticize our government officials. I wouldn't be surprised if suddenly they start coming up with some bill called the Patriot Act, or anti-terrorism, this or that, or the whatever it is, whatever the flavor of the month is going to be at the time, and they're going to, and possibly start coming after our ability. Well, some say it's under attack already, but I don't want to get into any political stuff. Those of you who know who Dr. Jordan Peterson is might know what I'm talking about. But anyways, I think that's about it. We've covered this pretty well, wouldn't you say?
Yeah. It does. If anyone has any questions, we'll be.
Folks?
I'm going to have Stacy pop around in here to say goodbye.
Everybody loves Stacy. Let's see if I can get
Another great conversation.
Hey, buddy.
Hey. I show up and Erekose leaves. I see.
What's up, guys? Sorry, I was just calling.
Oh, he's got no pants on.
He's got no pants.
No pants. Yeah, I'm in my underwear. No, I'm not.
Yeah, Stacy wants to know how everyone's doing.
Come here.
Did everybody have a good Mother's Day?
Yeah,
Well,
happy Mother's Day.
guys, but he's not cooperating. What's up, guys? Sorry. Yes, happy Mother's Day for everybody. What do you think? Yes.
Yeah.
So have you actually been able to keep a thumb on Stacy? Because I know in Australia, dude kept taking off on Ubers and taxis, and we didn't know hardly where he was half the time.
Yeah. No, I've only been here a couple hours. Well, maybe 10 hours or some, maybe. So I'll probably be the same. I'm always
7 hours.
I'm always I come from such a small place. I need to get away and decompress from all the stimulation. But right now there's a lot of footage now, and so I can imagine, what it's like. You have the footage that you can take 2 hours of footage, and it takes about 10 hours to make 2 minutes.
Sometimes.
So, yeah, but it's been great. It's been a very gracious host, and his family's welcomed me into the house. It's so wonderful. And Austin's, it was super nice here today. So we'll see what happens. I'm kind of excited, you know, just to keep going. So.
right on, buddy. It's good to see you there with Travis. So that's cool. Exciting.
Yeah.
You got the wrecking crew all abuzz. So.
Oh, good. Yeah, well, you know, I think it's the further I walk on this little project, the more I like it, and we'll see. I mean, it's all a brain. It's all just imagining what could be right now. So these are the first few steps, and yeah. But like I say, it's good to keep the conversation alive. Sometimes in these lows, you know, within my own mind, I go back to how long we have ahead of us. It's a lot, you know. It's not to be pessimistic, but there's a lot of time ahead of us. Take a look at how long this decision is taken. This is going to be the template for every decision, and that's one of the reasons I wanted to do a project like this, is to create content when there are lows, and to just overtly affect the narrative out there, because. Like when you're talking about the money thing, it seems like the state and the general media in Wisconsin they're always pro-state, and so I thought, hey, let's try and give something else for some, you know, people to think about. So we'll see if I can do it.
Right on, right on.
Yeah.
Sounds exciting, buddy.
Yeah.
You know, well, I've been talking with you about this for a while, so I knew this.
Yeah, that's right.
You know.
I literally have been talking about this project for maybe a year and a half.
Right.
So thinking about it.
Venturing off and taking the first steps on it. So
yeah, it's cool. You know, it just happened, and we'll see. I'm not a filmmaker by any stretch, but we'll see. I'm creative, so you know.
Yeah, you got the creative.
If all it fails, I can just put my songs, put a song each, sort of like upload, and keep pushing that avenue. So.
Hey, at least you can put your studio versions on your own videos.
Yeah, that's right. I get flagged myself, but I hope to get back to that studio too. I gotta get a hold of Mark. You know, that last little Twitter thing I did. That's actually that last song I did was on Twitter. It's actually another song with endless lyrics. I mean, it's insane.
Yeah.
I can rhyme this case till the cows come home.
Right. Right. Now they're getting used to it anyway, right? Getting a little practice.
Yeah, that's right. I'll have to get some beats and try some rap one day. Eh?
Dude, that was you're cracking me up. Folks, we were in the car. It somehow didn't make it into the recordings, but we were in the car in Australia and singing along to Stacy Seabrook. I don't know how I didn't get this on recording. Hey, guys, I don't know how I didn't get this on recording, but there was points where he was re-singing lyrics that had just come out of the radio, but he was doing it with this whole rap like edge on it. It was freaking hilarious. I wish I had it on tape because it was brilliant. It was freaking hilarious.
We'll get one out there. I'll get one out there eventually.
You and Travis, dude, that'd be perfect.
Yeah, we'll get the sideways ball caps on.
There you go.
Bling.
Travis, don't sing.
It's rap, dude. You don't have to sing.
Travis, don't play that.
Easy there, homie. Right on. Well, I hope everybody had fun. Like I said, reading that motion to dismiss is a lot of fun if you guys haven't. Literally, it's just like, you know, it's just awesome. So great talking with Stacy and Travis. Those of you out there who haven't already, please go over and subscribe to Stacy Seabrook. We need to get that guy to 1,000 subscribers for rally time so we can have him going live from rally. Same with Paul Capaldi, same with Tracy Strunzi, folks. Remember them as you go over and subscribe. And thank you guys for being here today. Obviously, it's a pleasure to see Stacy there with Travis in Texas. Yeah. A very special surprise for us today, so thank you for that.
Cool. Thank you for having it. And thanks for keeping the conversation going.
Yeah, absolutely. That's, my main goal. It's what I hope I can keep doing and keep these people interested. And there's really good core group of people now that are continuing to stay interested and looking into things every day, even though it's a lull, and that's a good sign. Even though it's
Erekose is the eternal champion.
Very, very true. Thanks for having us, and hope everybody had a great Mother's Day. And kind of sad to think about how Stephen and Brendan deal with a day like today, or that their mothers deal with a day like today. But thank you for having us.
Yeah.
Erekose, thank you for having me. And
Somebody asked how many you're at now, Stacy.
I think I just broke 700 today.
A little over 700.
And there's a big shout out for Diane, Little Misty 64 or 84 or something on Twitter. She's been promoting that. It's her new cause. So I wanted to say thanks. Yeah, sweet. We're going. It's getting up there. So I feel, since Mammothon, I think it's doubled.
Yeah.
So,
yeah. Around 300 something, right? Yeah.
Yeah.
So
cool.
Awesome. Hopefully we'll get you there. We got another month. So
yeah, man. Yeah.
Hopefully we'll get you there. Hopefully get Paul there, and hopefully get Tracy there. It'd be awesome if all of us Mammothon hosts and you are all going live from Raleigh. That'd be another exciting experience for everybody.
It'll be a Rallython.
Yeah, there you go, Rallython. Hey, we're not raising money, so we got to drop the thon.
Yeah, right. Okay.
So it's Mamaral. There you go, Mamaral.
Yeah.
Anyways, all right. Thank you guys for coming over and having a little chat about this today. Thank you for being here, Stacy and Travis. Thank you all, everybody who tuned in. If you haven't already, please hit subscribe for all the people we've before mentioned, including myself.
Yeah.
And we'll see you guys later. Be good to each other.
Okay. See you, dude.